Hey, everybody. Thanks for joining us. It is the Creative Finance Collective. If you're new to the Creative Finance Collective, here's what it is. It is a group of real estate professionals. And by professionals, I really mean attorneys that are in the creative finance space, whether they be transactional lawyers, whether they be litigation attorneys, so on and so forth, that come and practice in the area of creative finance and are there to discuss it and work through the issues relating to creative finance and to come at it from different jurisdictions. We've got a variety of different members on the collective, and sometimes they show up late, sometimes they show up early, sometimes they show up, and sometimes they don't show up at all. So as we get the show kicked off, what we do is we make ourselves available for the entire hour to answer any questions that our listeners might have. So if you have any questions for any of us here, we're here to do our best to answer questions that you have along the way. Just post those in the chat. We should have and do have confirmation on a number of different members that should be logging on. For the most part, who we have on here right now is myself. If you've watched before, you know who I am, Andy Fowler. I'm an attorney with the law firm of Fowler St. Clair. I practice in the area of real estate transactional, and have a history of doing real estate litigation as well for probably coming on 15 plus years. So know a little bit about that. I'm also the co-host of the NREM podcast, a podcast for real estate investors, which the collective is housed on. Also have with us here Elizabeth Best, who's an attorney with the law firm of Fowler St. Clair, a transactional attorney. Elizabeth, how you doing?
I'm good. How are you?
Good. So what kind of work are you doing right now? Are you doing any creative finance stuff?
I had actually a couple that we were working on. One was actually with a VA loan, which, if you don't know, title companies won't really touch those because the department or the VA won't work with those title companies anymore if they do. So that one we were going to have to do a little bit more work on the closing end, and so just trying to get all that set up. Unfortunately, the deal did fall through, and then we also had an FHA one, which was similar in that title companies don't really like to touch those. There's only a couple that will, and that one I think is still ongoing. It's just a little bit of negotiating that they have to
Yeah.
finish.
So when you say the title companies aren't touching them, what do you have to do? You have to just close outside of without the title company?
Yeah, we have to make sure that there's language in the contract, and the other documents saying that there's no title insurance, there's no title commitment, stuff like that, and that we have to prepare a settlement statement and stuff like that too.
So what's the risk profile that the investor has to consider if they're so if you're not gonna go through the title company, the title's not gonna touch it. So you're saying this applies typically to VA and FHA, right?
Right.
So if they're not gonna touch it, then the investor just has to be prepared for the potential risk associated with not having title insurance, right?
Yeah, they can still get a commitment, I think, from title companies to make sure. But if they don't do that, then they're not going to know if there's other open deeds of trusts or mortgages or liens against the property. So they'll want to make sure that they do a title search.
Now there's usually even in that case, you can still order
Mhm.
some products from the title company and at least to run like lien searches, right?
Yes.
Yeah, all right. So they're able to try to mitigate some of their risk on some of that. Hey, Brian, for those that are watching, Brian Locker, litigation attorney in both Arizona and Georgia, has joined us. Can you hear us okay?
I can. Am I coming through all right?
Yeah, you're coming through good. So we're really right now, we're just kind of talking through what Elizabeth's been doing on the transactional side of things with regard to creative finance deals and mainly talking about more recently her FHA and VA type deals. Now, Elizabeth, is you don't see that many of those, do you?
No, no. This is only like second or third, I think maybe we've come across or that I've worked directly on. So
So is it is it fair to say that most of the deals you're working on end up getting closed actually at a title company?
Yeah. Oh, yeah. Yeah. I don't think we've had to do any outside of title yet.
Okay, interesting. So we may get others that pop on here. I wanted to talk about a couple things. Yesterday we had on our podcast Bill Bronchick from Colorado, and we were talking about the hype relating to creative finance and what that's looked like and whether he's seen this kind of popularity surrounding it before. And he said that they hadn't. I thought this was kind of funny. I was going to show it to you guys. I'll show it to the other folks if they show up. Let me pull it up here. Give it a second. There you go. I saw this on Twitter, just locked in a 30-year mortgage at 8.36%. Congratulations, going to be a homeowner finally. I think that's kind of I think that's kind of how everybody's feeling right now. Do you think?
Yeah.
Looks like a deal. It's got a pool.
Yeah, I know. It's got a pool at everything that both you can swim in and your horse can drink out of. So
That's right. Is it a pool or a trough?
yeah, so that's clearly driving this market, the hikes in interest rates. And from talking with attorneys that have been doing this for a while, it doesn't seem like there's going to be any slowdown in it. And they certainly haven't seen this kind of volume to speak of. Now, Brian, you're a litigation guy, so you see a lot of it on the litigation side of things. What are some of the big litigation matters relating to creative finance that you're typically seeing right now, whether it be in Arizona or Georgia?
Yeah, it's getting pretty brutal out there. I will say that traditionally, let's say pre 2001, we had a settlement rate in creative finance deals where we had seller non-performance. We probably had a early settlement rate of maybe 80%. So literally 4 out of every 5 matters that came through the door were settling early and resulting in an acquisition of the property for the real estate agent. We're in a completely different market. I would say that 80% has dropped down to maybe 50 or 60%, where either the matter is settling much later on in litigation. So the real estate investor is having to put much more money into the fight, into the litigation to sort of force the parties to the table, whether that's a seller, whether that's another competing buyer, as the case may be, or it's having to go to trial altogether. I mean, it is an incredibly competitive market, and it reinforces the fact that investors out there who have non-performing sellers 100% need to be papering their transactions. So if they have a non-cooperative seller, they need to be getting emails, they need to be sending text messages, they need to be building a file that they can deliver to the attorney after the fact. And they can't just be sitting on these files. So, we've had cases in the past where, things were just gangbusters for these attorneys or for these investors. And so if they had a non-performing seller, they would just sit on it. They would record a memo and just say, we'll figure it out later.
So
right?
let's break this down briefly. So when you're talking about a non-performing seller, we've got a subject to deal that just hasn't closed escrow, and the seller gets cold feet for whatever reason and says, I'm not moving forward. Is that what we're talking about?
Right. Yeah. For whatever reason, they sign the contract with the buyer, with the investor, and sometime before close of escrow, they've either refused to perform, refused to cooperate with title, as the case may be. You can't close, and it's due to the seller's non-compliance.
And your threat to the seller, or the buyer's threat to the seller, is I'm going to force you to perform. The contract requires you to perform. I'm going to bring a specific performance action in court to force you.
Sure. Yeah.
So previously, you did, so previously you'd send what, a demand letter with the filed lawsuit and be like, hey, here's where this is going. You can either settle this or we'll see you in court.
Right. Our recommendation has traditionally been send a demand letter, attach a draft complaint to the letter saying, look, you've got about a week to let us know that you're going to comply, or we're going to file this attached lawsuit. That's historically been the strategy.
Okay. So you mentioned there's, so these deals aren't, or the settlement rate isn't what it used to be. So there's been a major drop off. What do you think the drop off is due to?
Much more competitive environment. So you know, the buyer, the investor may be getting the homeowner to sign a contract, but then a week later, I mean, they'll have, you know, these are traditionally these sellers are in foreclosure, right? That's the, by and large, the most common way that these buyers are finding these leads, is because there's been a notice of foreclosure recorded with the county.
So it's a distressed property.
Distressed property. There's some immediacy, but also this is all public record, right? And so you may be the first one to the seller, but they're going to have 10 other inquiries, right? And so you may be able to get to them first and get them to sign a contract, but they're going to hear from 10 other people over the next 48 hours.
So maybe the first guy that calls says, I'll do a deal that maybe brings you current or something, and I'm going to buy it. Then the next one comes in after you sign the contract. I'll bring you current and then bring in 10 or something like that.
Sure. Yeah. Yeah. But here's what happens, right? You sign, I'm just going to use, fictitious number. Let's say you get under contract with that seller for $100,000, right? But, investor B comes along and says, oh, you signed a contract with so-and-so. Yeah. What did he offer you? Right. Oh, 100,000. Oh, I'll give you 105. Right. Knowing that, this is probably a fairly unsophisticated seller, and they'll say whatever it takes. They'll say, oh, that contract's not enforceable. You can go ahead and just sign with us. Right. And they'll get a contract for 105. And then in some cases there will be a third contract, right? There for 107, as the case may be. Right. And now the investors are stuck in a position where they have to go fight with each other. Well, historically, that hasn't really been the case. I mean, obviously that happened on occasion, but now that's the norm. And so if you're buyer number one, and the seller comes back to you and sends you a text message and says, you know what? I had to think on it and I decided I'm not interested in selling to you. Sorry. It was very common for the buyer to say, all right, you know what? They don't want to comply. I'll just record a memorandum and we'll see what happens. Right. You can't really do that anymore, because these downstream buyers may or may not be aware of you, but they're going to go close on that property and they're going to make arguments. And what we're finding is there might be some time that elapses. There might be other reasons why this property is distressed. And so it may not close 30 days after. It might be 6 months down the road, but the seller, for whatever reason, has decided to cooperate with another buyer. And so this downstream buyer has invested time and money into this property, and they end up closing whether or not they're aware of your lien or not. And what we're finding is there's a lot of pushback on these first position lien holders to say, look, if you didn't go and try to enforce your rights immediately or shortly thereafter, we're going to claim a theory called latches, basically saying, look, these other guys invested money and time into the property, and because you sat on your rights, you forfeited your right to enforce your contract.
Well,
Um,
let me come back to this real quick. If you're just joining us, everybody, this is the Creative Finance Collective, and we're talking about all things creative finance, whether that's transactional, whether that's litigation or litigated disputes over a creative finance transaction. If you are joining us, we're taking questions. Feel free to leave a question in the chat, and we'll get to it. So, uh, Ryan, back to this issue of the litigation you're facing, that you're dealing with, and seeing these and lots of time elapsing and dealing with defenses of latches and maybe others. You had mentioned earlier that some of the problem is a failure on uh, the some, maybe all of the parties' fault of documenting some of this and keeping track of what's going on. What do you mean by that, and why is that important?
So just this week, I've had two separate cases, one in Georgia, one in Arizona, where the fact issue at play is what happened between my client, the buyer, and the seller. What was the issue? Was the seller the one who was not performing, or was it the buyer who got a contract and just decided he didn't want to perform, so he's just going to record an interest and deal with it later? Right? There was no actual interest in closing that deal at the time, right? That's the allegation. It's in the interest of the seller to say that. It's in the interest of the downstream buyer to say that,
Sure.
right? And so the question becomes, okay, can we prove that it was the seller that was the one that didn't want to perform? And so my question to the client is, produce your text messages, produce your emails, produce your phone records, right? What do you have? And in both cases, the buyer had nothing. And one of the reasons they had nothing is because so much time had elapsed from the original interaction with the seller that emails were, deleted, text messages were lost, whatever the case may be. They had no contemporaneous records of the interactions between them and the seller. And so when I have another attorney saying, look, the seller's saying that your guy is the one that didn't want to perform, not them. If I don't have anything to show them that it's untrue, that becomes problematic from a litigation perspective.
Yeah, it's just he said, she said, right?
Absolutely. And you don't want to take a case like this on a he said, she said, right? You don't want, as an investor, to spend tens of thousands of dollars, right? Upwards of $50,000 to $75,000 on a he said, she said, right? You're rolling the dice. I mean, you would have to have such a tolerance for risk under those conditions that I don't foresee a scenario where it makes sense unless there's just so much upside for you in that transaction that you're just like, I'm just going to throw money at this thing, right? But most investors aren't in that place. Most investors aren't like, hey, I've got 50 grand to just like throw around on litigation, hoping that I can make this deal work, right? That's just not the case most of the time. So it becomes very difficult for someone like myself to make that work.
Well, let's talk about then, in a perfect world, what the investor could do here to try to fix the problem. And now, so you mentioned contemporaneous record, and obviously contemporaneous record for us as lawyers, that seems obvious, but it's a written record made. I guess it could be a orally recorded record, I suppose, made at the time that the event happened, right? Not a recollection of what happened 6 months earlier, but a notation made at the time that it happened, which adds authenticity to that note. I would imagine one of the big problems, and this isn't just unique to real estate investors, this is just unique to probably just entrepreneurs generally. They're movers and shakers, right? They don't have time to go write something down. So a lot of this probably is a policy and procedure, or a procedure problem, just in how they work. Do you have ideas as to what they ought to start doing in order to plan for these types of defenses that they may make sense, other than, hey, just start making written records of things that happen as they happen? I mean, email's easy, right? But phone calls aren't as easy.
Yeah, I mean, obviously this looks different depending on who the investor is. I know there's some investors that are using these conversations with potential sellers as part of the media they're putting together for for advertising and marketing. So they're recording everything that they all their calls with sellers already, right? So that makes it far easier to just say, hey, look, if I have a conversation with a seller, I'm going to throw this in a Dropbox file somewhere. And so if it ever becomes an issue, I have it, right? That's easy. If you don't have that, then, it could be something as simple as, hey, for every deal we've got a spreadsheet in the file. So anytime, a transaction coordinator or whoever interacts with that client, there's a notation. So we have a date, we have a time, and we have the substance of the communication written down in an Excel spreadsheet, right? That's sort of that's bare minimum what you would want to see. But ideally, you've got actual communications with the seller. You're communicating with them by email, you're communicating with them by text message, whatever the case may be, and however that's happening, it's finding its way into a file that can be referenced at some later date. That's what we need to see, because these are becoming fact issues, and the reality is that a lot of buyers aren't keeping these things, and it's making the litigation after the fact very difficult.
Now you're a pretty techie guy. Are there third party? It seems like the emails, as long as you keep your emails and you keep things in writing, that's simple enough. But even for us as lawyers, we're used to this when we're communicating with a client about like a settlement offer they authorize us to make. It's like, well, okay, if I did that by phone, I need to make a note of that I had the authorization. So I'm going to make a contemporaneous note somewhere. It really becomes a difficulty when you're dealing, I think, with the phone calls. Are there third-party apps that you're aware of that could be used or that would help facilitate kind of keeping that kind of record?
I know that there are apps that you can have on your phone that will automatically record phone calls. Free services like Google Voice will record phone calls that and you can download MP3s after the fact. And I know
I guess I'm thinking of just like, like for you and I, lawyers have billing systems, and we're always billing our time and writing down. We've got systems that'll capture that. Are there third-party apps that, because I know there can be legal issues depending on different states with just recording calls, but just notation apps that allow you to make contemporaneous written records?
Sure. I mean, any CRM is gonna have the ability to make records like that, and so I mean, there's 1,000 of those things out there to use. I mean, just plug sales CRM into Google and go to g2.com and you're gonna have a a smorgasbord of options available to you to be able to keep contemporaneous records of your sales process with any lead. So, I mean, that's like a day one type thing. If you're an investor, if that hasn't been implemented into your workflow, it needs to happen tomorrow. I mean, it's essential.
It seems like, too, what I'm taking from this, the investor that's most at risk are the ones who, like you said, have recorded a memorandum and have just sat on their hands and waited, figuring that the memorandum was going to be enough. Do you agree with that?
Very much so. That is one of the issues we are seeing right now, is that we're seeing this large amount of time pass between when the original contract is signed and when the dispute ultimately sees the light of day. And I think there is this sentiment out there in the community that, hey, as long as I've got a recorded interest out there, I'm good. I can just sit back and wait for the issue to rear its ugly head at some point down the line, and I'm going to be fine. And the answer is that's not the case, right? You cannot sit on your rights. Are there scenarios where that will work out for you? Sure. I had a deal last week where the lien was 6 months old. They didn't do anything. They just sat on it until the seller decided they wanted to sell to someone else. The lien popped up. We negotiated a payoff. Done. The investor was thrilled. They got a 5-figure payoff. But that is becoming the exception to the rule. The rule now is if you just go record your lien and just hope that's going to be enough, expect to spend a bunch of money with a lawyer to protect that interest. And it's not going to be a straightforward priority issue where you can just, be comfortable in the fact that you were the first one to get the signed contract. That's not the end of the discussion.
Now, have you had situations where judges have found the latches argument persuasive and it's gone that far? Or is it just a matter of there's so much competition out there and this is a defense lawyers can grab onto, so there's just a lot more people willing to put money up to fight it on that issue?
Right. So the latches argument, because just in case people aren't familiar with it, the idea of the latches argument, it's an equitable argument, right? So the idea is that, for example, in Arizona, there is a 6-year statute of limitations for contract actions. So technically, when you enter into a contract and the seller breaches the contract, under Arizona statute, you have 6 years, and that's pretty consistent from the jurisdictions that I'm familiar with. You have 6 years technically to bring that breach of contract action. An exception to that rule is a defense called latches, which means that there can be circumstances that arise outside of just the standard 6-year statute of limitations where it would be unreasonable to allow someone to wait 6 years to enforce their rights under a contract. And a perfect example of that, for instance, is you have another buyer that comes in, closes on their contract after you, invests substantial amounts of money into the home, then goes and tries to resell the home 8 months later and discovers your interest, right? At that point,
right,
we have a third party who's invested a bunch of money into this home and you've just been sitting back. If you end up with that home, let's just say there's been $50,000 invested into that fix and flip. You would be unjustly enriched by being awarded that property. And so now we have this issue of what do we do with this downstream buyer who invested all this money and you've been just sitting back waiting for the dispute to arise so that you can go enforce your interest. That is the kind of thing that we are seeing, and the argument that we're seeing from sellers, downstream buyers, where they're saying, look, it's not fair that you get to go enter into this contract, sit on it with a memorandum on file, and then reap the benefits of someone else's hard work, right? I mean, these are the arguments that we're seeing. I mean, is that going to be successful? Right. Andy, you were saying, have we actually seen judges rule on this issue? Well, right. The reality is that 95% of these cases settle.
Sure.
Without rulings on these legal issues, because it's just too risky for an investor, especially, to roll the dice like that. So they're going to end up settling, but these are the risk factors, and those issues can be mitigated by these things that we've been talking about, like papering your file with evidence that the seller was the one who ghosted you. The seller was the one who affirmatively communicated that they wouldn't perform. These types of things can mitigate these issues after the fact. But if it's just a he said, she said, and then you've got another investor who, who's come in, you're opening yourself up to losing losing your equitable interest by, by virtue of these arguments that are being made, that it's not fair that you get to just sit on your rights.
Now, are a lot of these cases happening? Are they effectively the other investor that comes in and buys or enters into another contract, despite the fact that the original contract had a memorandum recorded and so on and so forth, and they had an executed contract? Are these happening after the closing of a sale to another party, and you're trying to unwind it, or is it are these being caught pre-close?
Both. So I have multiple cases in both situations. So I will say the majority of the situations involve scenarios where the home hasn't yet closed. So you have the seller who signed a contract and then breached the contract with the initial buyer, and then at some point in the future signed a contract with another buyer, usually for more money, and then in the process of closing on that second transaction, the lien on the first transaction is tripped, and so the property hasn't yet closed, right? And so then the negotiation is over who has priority in that case. Is the first contract still enforceable? And if not, what happens? And so that's situation number one. Situation number two that I've had a couple of times is that it is after close, and that can occur in two different scenarios. Scenario number one is the second investor, the downstream investor, closes outside of escrow. So no title insurance policy was pulled, probably because they knew about investor number one, right? So title is not going to issue a policy where there's a memorandum on file, right? And so they'll just take it outside of close. They'll take title, and then they'll initiate litigation against investor number one, alleging that the contract's unenforceable, right? We see that. Situation number two just came up in a case that I got last week, where title did close escrow. And the reason it closed escrow is investor number one recorded their contract within 24 to 48 hours of close of escrow. So the initial commitment for title cleared, right? There was no lien that showed up on the title.
Right, didn't show. Yeah.
Investor number one records prior to close, title doesn't catch it, they close escrow, and then investor number two does their fix and flip. They try to sell to their end buyer, and now the lien shows up in the chain of title.
Okay.
And so then, yeah, you're after close, and so typically the title insurance carrier will get involved and contact investor number one, which is what happened in this case. And then there's an argument over, okay, what happens? How do you deal with the priority issue where there was only 24 hours between when you recorded and when the transaction closed? Did that lien actually attach and bind that second investor? So we're seeing both situations.
Yeah, interesting.
Yeah.
Okay, so the moral of the story is if the deal doesn't close, don't sit on your hands, right? Pursue it. Get out there.
Yeah.
Maybe get the action on file right away. Get the letter sent right away, because chances are with the competition in the market, right? It's coming.
It removes a major argument from the seller or the downstream buyer. It removes a huge argument that they have in their arsenal, because if you quickly, I mean, within 60 days, if you try to enforce your contract within 60 days, they can't make the argument that you sat on your rights. I mean, but once you get past 60 days, once you get past sort of your grace period under your contract, there's a lot of arguments that they'll start making that call into question the enforceability of your contract. Doesn't mean your contract was unenforceable, but the harder it is to enforce that contract. So yeah, highly recommend in this market with what we've got going on now, if you want to record a memorandum and you're doing it pursuant to the laws of your state, that's fine. That's great. But plan on enforcing your contract within 60 to 90 days. Otherwise, you're just asking for trouble.
Yeah. All right, folks, if you're just joining us, this is the Creative Finance Collective. We're talking about creative finance. With us, we have Brian Locker, a litigation attorney in the states of both Arizona and Georgia, and a transactional attorney, Elizabeth Best, both here to talk about all things creative finance. If you have a question, post it in the chat. We do have a question that was posted. Let me read this here. It says, let's see, wanted to confirm, when closing a sub-2 in a land trust, is it possible to name the trustee my LLC? So we're Arizona and Georgia lawyers. I don't know what state you're referring to. One of the things that I would mention to this, the person asking this, it's a Facebook user asking this. One of the go-to guys and attorneys on land trust is a lawyer named Bill Bronchek. They're out of Texas. A lawyer named Bill Bronchek out of Colorado. And Bill does a lot of work with land trusts. He does a lot of work with land trusts because of the advantages that it can provide with regard to anonymity. I would take a look at our podcast from just yesterday. Bill Bronchek was a guest on our podcast yesterday. It was called Creative Finance Grad Level, and we talked about closing a sub-2 deal with a land trust. I'd take a look at that. I'm not sure how you would structure that. I don't know why you can't make a limited liability company the trustee on a land trust. I don't know why you can't, but I don't know whether there's restrictions in Texas. But what we're going to do, and he may show up, keep watching. A couple of our members of the collective that are oftentimes here are Texas attorney Scott Horn and Texas attorney Alan Seshker. They may show up and we can pose that question to them as well. But I'll write your question down to ask them on a following episode if they're not here. They're usually here just about every week. But you'd want to obviously confirm that you could do that in Texas. I don't know. Brian, are you aware of any reason? We don't really do many land trust here in the state of Arizona. So, and there's other ways to obtain anonymity. That's usually what you're doing when you use a land trust, is try to obtain, to do it for anonymity. But I don't see a problem with doing that. But like I said, you'd want to confirm with a Texas lawyer.
Don't you typically want a disinterested party, or an unrelated party being the trustee on a? I guess I might be confused on what the question actually is, but are they? I guess maybe they're saying the trustee of the trust.
Yes.
Okay.
The trustee. I believe what they're asking is with a land trust.
I was thinking in the context of maybe the deed of trust on a sub-2, like the wrap.
Yeah, no,
right?
This is a land trust, and I'm presuming that they're doing it. Yeah, and they said yes. So that's the question. Can you make an LLC the trustee of the land trust? They're using
in that case, I don't know why you wouldn't be able to do that.
Yeah, I don't know why you wouldn't be able to do that. Like I would mention to this user, being that you're in Texas, stay with us. Let's see if Scott Horn was originally supposed to be on the program with us. And if he's not going to be on, he'll end up being with us next week. So we'll get that question answered. But I check our podcast from yesterday. Bill Bronchek from Colorado does a ton of land trust. They love to do them there. So hopefully that gives you an idea about how to tackle that from an Arizona's perspective. I don't see a reason. I'm not aware of a prohibition that you can't make your limited liability company the trustee on that.
If I remember correctly, I think Sean St. Clair had mentioned that is another way to do it. We typically do the trust owning the LLC, but you can do the reverse. But definitely check out with a Texas attorney.
Yeah, and they typically do that. Do you, Elizabeth, usually include the land trust when they're trying to maintain the anonymity? Is that the main reason?
Yeah, it's just adds another layer to it.
Yeah. What is the more common? It seems to me the more common way we try to achieve anonymity here in Arizona anyway is through.
You do a land trust that then is going to be the member of an anonymous state LLC. So we used to do a lot of Delaware. We do a lot of Wyoming. New Mexico, I think, is also one. And then you use the Delaware LLC as the member of the Arizona LLC. So if you were to look it up on the Arizona Corporation Commission website, all you see is the Delaware LLC. If you try to look it up in Delaware, you can't get to those records. And then you use that entity to be buying everything.
Yeah, and the problematic thing that we have here in our state of Arizona is there is a statute that requires when you convey in and out of a trust that you disclose the beneficiaries. And that can defeat what you're trying to achieve with anonymity. So it's less, which is the case probably, Elizabeth Weiss. It's more often the reverse scenario where the trust owns the LLC and the LLC owns the real estate. So there's not a requirement that there be a disclosure of beneficiaries. We had another question, not posted here, but that says, you mentioned last week buying up the interest of siblings and filing a lawsuit. What is that lawsuit called? So Elizabeth, you were here. Brian, you weren't here. But I'll give you kind of the background context of what they're talking about there. Scott Horn out of Texas was giving us stories about buying up siblings' interest, inherited interest in real estate, and what it took to track that down, and then bringing an action to kind of sever the interests of the remaining siblings that, for instance, didn't want to sell the property. So this question is, what is that action called, and what does that look like? You've done those before, right?
Yeah, partition, generally.
Is the process look a lot different in Arizona than it does in Georgia? Or are they pretty similar?
No, they're pretty similar. I mean, the idea being that you have communication with one of multiple beneficiaries, right? And so you can acquire one beneficiary's interest and then use that to then negotiate with the other beneficiaries. If they're not cooperative, then you can initiate litigation to liquidate your fractional interest in that property. And in that process, the idea being that, hey, you sort of force them to the negotiating table to say, look, you're going to have to go hire an attorney. You're going to have to deal with the fact that the property is getting sold. Just work with us. We'll give you a fair price for your interest in the property. And we've got a pretty good success rate of generally people who inherit property are reasonable, unless they're like occupying the property. Sometimes you've got like 3 siblings, right? And 2 of them are out of the property. One of them's sitting in the property. Maybe they were taking care of mom or dad on their deathbed and living there at the property. And their idea was, I'm just going to keep living here after they die. And brother or sister A and B, I don't have any interest in that. And so the investor can come in, acquire A and B, and then litigate with C and figure out how to get their interest. And so that's not uncommon.
If you're just joining us, this is the Creative Finance Collective, and we're talking about creative finance and real estate type issues. We're taking questions the entire hour. If you have a question, you just put it in the chat, whether you're on Facebook, whether you're on YouTube, whether you're on Twitter. You can leave a comment, leave your question, and we will answer it. One healthy debate that we got into last week was over basically just investors willy-nilly using assignments and backing out a deal, and disputes that were happening over assignments. A lot of those happening in the context of wholesaling type deals. I don't know how much wholesaling we're seeing, but Brian, you've handled disputes over assignments on wholesale contracts where an assignee downstream is failed to perform and finish the contract, right?
Yeah, for sure. And I mean, there's a number of issues that can arise out of deals like that, where the assignee, for whatever reason, hasn't performed, hasn't closed on time. Sometimes it's not even their fault, right? But there's typically a fuse on these on these assignments, whereby if closing doesn't happen by a certain date, then the rights to purchase that property revert back to the assignor, and you better have something in writing or an agreement in place with the upstream buyer to either extend that period of time, or have that figured out, because that can create all sorts of issues um, regarding the enforceability of your contract.
A lot of it comes down to the language in the assignment itself and whether you're using a good form or not, right?
Yeah, and a lot of these forms all look the same. They have the same language, and frankly, they don't properly account for common scenarios where sellers don't perform. There's just a hard date where the rights to the purchase of the property revert, and that's created major issues for us in the past.
Interesting. Question, maybe this one's best for Elizabeth. But I've seen this question come up, and I think we've mentioned title companies a couple times, but how important is it to find a title company that is cued into creative finance transactions? What do you think, Elizabeth?
Very important. Just because if they know what they're doing, it just makes the whole process seamless and easy, and they can assist with the buyer and the seller and everything. And we run into it not just in creative financing, but client is trying to sell a property and the title is telling them, oh, well, you have this issue. And then we have to go explain to them, no, you actually don't have this issue. This is why this is allowed. And which just, cost the client money and stuff that they wouldn't have to use if they were using a better title company or a more informed title company.
Now we had, I see another comment that we had in Facebook, and I think it's worth discussing. It says land trusts don't protect you any more than having the property in an LLC. I think it's worth mentioning that comment to note, just kind of going back to land trust. The only reason that land trusts are to be used, because at the end of the day, a land trust is just a revocable living trust for the most part. That's basically what it is, which is not really any different than your typical estate planning trust. A living trust that a husband and wife might have in just a family situation. Those trusts are not at all designed to be a liability shield. So, so to be clear for the viewer that might be watching, any recommendation to use a land trust is not to be a liability shield. It provides zero liability protection. It is correct that a limited liability company does. A land trust does not. The land trust, its sole real purpose and use has been to provide that anonymity, to provide anonymity. That's it. So a lot of times where you want to have some sort of liability protection, there's going to be a combination and use of the LLC in conjunction with the land trust itself, so that you get that. Elizabeth, you were mentioning before the trust owning the limited liability company, which then in turns owns the property, right?
Yeah.
So that's what's going to give you kind of the best of both worlds. Now, it can be anonymity, at least in Arizona, can be achieved without a land trust. You've just got to, Elizabeth, you've got to go to a state that has anonymity, like a Wyoming or a Delaware, right?
Right. Same kind of thing where you form it there, and then an Arizona one where you only see the Wyoming information.
And then you have to, but then what you have to do is be careful in what you do with that company when you bring it back to Arizona, right?
Yes, because it is a public record, so you have to list members, managers, addresses. So what we do for clients is we use our address, use us as the stat agent, and then you have like the Wyoming LLC as the member with the Wyoming address. So it's pretty anonymous that way.
Right. And the biggest thing, you don't have to domesticate. I think
You don't want to you don't want to do like the application for authority to transact business where you're moving or allowing the foreign LLC to do business in Arizona, because you still have to disclose members and everything. This way, if it's the Wyoming LLC owning the Arizona LLC, that keeps it anonymous.
Right. Yeah. And we got a Facebook comment or question. States won't allow anonymity though, right? No, states allow anonymity. What some states don't allow, or so I shouldn't say don't allow, but what many states require, Arizona included, when you form a limited liability company here, they require that you disclose the owners of that LLC. So in order to kind of get around that, you've got to go to a state that does not require that, because you can have a Wyoming limited liability company that owns property in the state of Arizona. You can have a foreign company that owns that. Where you run into difficulty and where you got to be real careful is you can't have a undomesticated foreign limited liability company bring a lawsuit or be involved in a lawsuit in the state of Arizona. It's got to be domesticated. So there's a process that has to happen there. Now there's a follow-up question. I think this is worth discussing. I've heard that it also might help to not trigger the due on sale. Is that true? So what I think this question is getting at, and this is interesting, and again, I would encourage the Facebook user who asked a question to watch yesterday's podcast with Bill Bronchek. He mentioned this specifically. So what this is getting at as kind of a workaround on the due on sale clause is the St. Germain Act, which is federal law, which allows you as a property owner to create a revocable trust, and it allows you for estate planning purposes the ability to convey your property to that real estate. Now that act is in it of itself. So transferring your real estate to your trust that you've created for estate planning purposes, that act is technically a violation of theoretically just about every due on sale clause that's in existence. Maybe not some, but usually it's going to be a technical violation of that. The St. Germain Act said, no, we're going to allow people to do that for estate planning purposes. That's okay to do. So Elizabeth's an estate planning attorney. I do some estate planning. We can freely transfer an interest in the client's real estate into their trust in order, and that's not going to be, the lender's not going to call that loan due, because that federal law prohibits the lender from doing that. So what this question is getting at is, can you create a land trust and avoid the due on sale clause by conveying it to that? Now, the thought was, and this might be accurate, and Bill Bronchek yesterday from Colorado talked a little bit about this, that the thought was, well, to not trigger the due on sale clause, let's just create a land trust, which is a revocable living trust, and we'll just convey it to that, and that won't trigger the due on sale clause. So I think that was done to some extent to try to create a transaction that looked like it was being done for estate planning purposes. Now, could a lender look back at that and say, well, was that really done for estate planning purposes? I don't know, or whatever else. But on its face, the transaction on its face, a conveyance from you individually or some company to a trust, a living trust, looks like it's protected by the St. Germain Act. So yes, that's why it was initially done. Now, what Bill went on to note is, even though they started to do that a lot, I'm not sure a lot of folks are doing it anymore, because everybody got to the point where I think they realized, like, the lenders just don't seem to care. Like the lenders just don't seem to be looking at it at all. The thought was, lenders are going to be bothered by this. The lenders just aren't even looking at it, so that's the issue. But that's what that's getting at. And, if the lender were looking, it would look more like an estate planning transfer. It is true if on the deed it was going to a trust. So there definitely could be some legitimacy to that. What other kind of stuff are you seeing, Brian? Any other kind of big litigation matters popping up?
Seller non-performance is always going to be a big issue. And obviously we've spent a lot of our time talking about sort of disputes that arise between buyers,
right,
competing buyers, but we are still seeing a ton of litigation directly between seller and buyer. And in particular, one of the things that we're seeing is around issues dealing with capacity. And one of the reasons why these leads come across investors' desks is because these homes have, as I mentioned earlier, fell into foreclosure. One of the reasons why a home might fall into foreclosure is because you have an elderly person who for whatever reason isn't as good about keeping up on their payments or what have you. And one of the things that we've discovered needs to be really on an investor's radar is evaluating that seller for capacity. If that seller is over 70 years old, right, there are a host of other issues that could jeopardize your contract aside from just seller non-performance, right? If that seller doesn't have the capacity to enter into a contract in the first place, you might be wasting your time. So we're seeing that.
So you're seeing that defense raised.
Oh yeah.
Yeah.
Yep. Absolutely. And then it becomes, again, it's an issue of fact, right? So the allegation is raised that, hey, this person wasn't able to contract at the time that you entered into this contract, and so you need to just let your contract go. And the question that is raised at that point is, okay, well, why? Tell me, what is it about it can't just be the age, right? It has to be more than just the age. So show us what that is. And we've seen a number of, pieces of evidence delivered, whether it's doctor's notes or, prescriptions. It could be a number of different things. And you just kind of have to take the evidence as it comes to do that. But it's an issue that I don't see talked about a lot.
Yeah.
But especially in Arizona, Florida, places that have a lot of retirees, that is an issue that will come up. And oftentimes, even if it's not legitimate, right? You've got an elderly person who may be who may have full capacity. But then the kids who would be inheriting this property discover what mom or dad has done, and they're the ones that come in and say, whoa, you sold the property for what? And I would say it's a very natural reaction to say, we need to protect mom, or we need to protect dad from entering into what we perceive to be an unfair contract. And so that's something to really keep in mind. And when you're negotiating with a seller who might be older.
Yeah. And there was another interesting issue. We don't have time to probe it tonight, but maybe next week. But following from that, not only, let's talk about the legitimate cases where they're not just raising a defense, but they could be on the edge of capacity, and elderly individuals who, it doesn't have to be just elderly people who have an incapacity or lack capacity, but going along with the hypothetical here, you can have a situation where you have lucidity at times and not lucidity at other times. And you can have a situation where there is capacity to enter into the contract. So you enter into a subject to deal with a seller, and they have capacity at the time, and then they lose capacity before it closes. What do you do in that case? We actually had a probate attorney here in Arizona on as a guest a couple months ago, Lou Silverman, talking about there's a probate procedure. I think it's called single transaction authority, but there's a quick process that you can go into probate court when somebody's lost capacity, but they still wanted to sell it. They just don't have the capacity to sign and close. There's a special emergency procedure available to go in and basically finish out that deal. But that's something, whether it's just being raised as a defense or whether the seller's just teetering on, capacity. They may have it one day and they can lose it the next day. As I understand it, folks in certain situations, like with dementia and Alzheimer's, there's different times of the day where they have more lucidity than others, where there's possibilities where they have the capacity to contract it like one time of the day, maybe like the morning, but by the evening it's gone. So that's just something, as an investor, you need to be prepared for. So, hey guys, we're at an hour. I'm not going to take any more of your time. It was a good discussion. We got good questions. I appreciate you taking the time. And if you're just joining us, this is the Creative Finance Collective. We do this once a week. We get together at 5 p.m. Arizona time to discuss all things creative finance. And we have at times 3 folks show up and at sometimes 10 folks show up. So we're there to answer your questions and discuss the issues relating to creative finance. Brian and Libby, thanks so much for being with us. Appreciate it.
Yeah, no problem.
All right. We'll see you guys next time. Have a good week.